As you know, delinquency is also related to a range of negative school experiences, including poor school performance, low attachment to school, low school involvement, low education goals, and poor relations with teachers. Delinquency is also more common in certain types of schools, including schools that are large, have poor discipline, provide few opportunities for student success, and have low expectations for students, and have poor cooperation between teachers and administration, and low community involvement. Several programs have been instituted to address these factors. Some focus on the individual, and others attempt to boost school performance. Programs focusing on altering the classroom environment, for one, involve anti-bullying programs, implementing more strategies for interactive teaching, proactive classroom management, and cooperative learning groups under this group of programs that focus on altering the classroom environment. Another area is changing. Another area of programs that focus on the role of school and delinquency prevention is changing the school environment, which begins with setting up a team consisting of administration, teachers, parents, and students, and others to create a plan to implement suggestions to improve. And these areas could focus on school performance, disciplinary rules, classroom management techniques. Then there's another group of programs that focus on individual traits, usually offered at the preschool level and then at regular school. It's community treatment programs used to rehabilitate juveniles. These traits are often the function of biological or early family environment, so the school gets involved and has programs that focus on these individual traits. Other programs, awareness programs, talk about the dangers of drugs and delinquency, behavioral programs such as training to resist peer pressure, and linking schools with after-school activities in the community as well. And schools have been attempting to be more responsive to the needs of students, but of course, despite the availability of funding, there is funding for these programs and options. There isn't always enough to go around, and now we are seeing this more than ever in light of the country's current state of affairs. A lot of budgets are being slashed, and they usually start at the level of programs. Legal rights. Do children have legal rights when they go to school? Protections under the U.S. Constitution. They don't leave their liberties at the doorstep of school, but unfortunately, school administrators find themselves fighting their positions or defending their conduct in courts, and a lot of cases have made their way up to the United States Supreme Court, and the court has handed down many decisions involving children's rights as it relates to their participation and presence in school and school activities. So most of these cases are going to focus on children or a child's right to privacy, right to free speech, and also talk about discipline in school. Let's start with right of privacy. The job of school administrators is to preserve an environment conducive to education and to secure safety of students. But where do we draw this line between this goal and students' privacy? Not to be searched personally, their person, or even their possessions. And the Supreme Court has given us some answers. First case, New Jersey versus TLO, and they use initials of children that come out of juvenile proceedings because they're private, and they may not necessarily be the child's initials. Sometimes they're made up initials to keep the student's identity private, because juvenile proceedings are private, as we'll talk about when we get to juvenile courts and how it works. So a little bit about the case. I want to expand on some of the information in the book so you can put the case in context. TLO was a 14-year-old female student at a New Jersey high school. A teacher found TLO and another student smoking cigarettes in the girls' restroom in the school building in violation of school rules. The teacher brought the two students to a school administrator who questioned each of them. The second student admitted to smoking cigarettes. TLO denied the allegations. The administration then accused TLO of lying and then demanded to see her purse in an attempt to find cigarettes. Among other things, when the administrator opened the purse, he found packed cigarettes, cigarette rolling paper. Due to the fact that the administrator knew that cigarette rolling paper is used to smoke marijuana, he now suspected TLO of marijuana use. He further searched the purse and found a small plastic bag containing a grass-like substance and items that could be drug paraphernalia, including a pipe, a wad of money, and a piece of paper with names of students who apparently owed TLO money, and a letter that appeared to implicate TLO in dealing marijuana. The administrator contacted the police, who in turn contacted TLO's mother. Her mother brought TLO to the police station, where she confessed to selling marijuana. Due to her age, TLO faced delinquency charges in juvenile court. The juvenile court denied TLO's request to keep those, her admission statement and those items that were found in her purse out, claiming it was a violation of the Fourth Amendment of being free of an illegal search and seizure. And so the case went all the way up to the Supreme Court. And while the court did not say whether or not a unlawful seizure occurred by the school, what it did, as it explains, the court concluded that under the circumstances of this case, the search of TLO's purse didn't violate the Fourth Amendment to the Constitution. The court did not address the issue of whether the unlawful seized evidence should be suppressed in and of itself, but it did decide that the Fourth Amendment does apply to the school officials. So the court made their ruling that the Fourth Amendment's prohibition or unreasonable searches and seizures is not limited solely to the actions of law enforcement personnel. It also applies to conduct by public school officials. Public school teachers act as agents of the state and not merely agents of the students' parents. Therefore, the Fourth Amendment applies to their conduct. The court also stated that students have some legitimate expectation of privacy at school. However, the students' expectation of privacy must be balanced against the needs of school authorities to maintain an educational environment. So as such, school authorities do not need to obtain a warrant or have this fancy term called probable cause that a crime occurred before searching a student. That's what law enforcement needs. Rather, the reasonableness of a search under the circumstances will be determined. And to determine what's reasonable, you have to look at two things. Was the search justified at the inception? And two, as the search was conducted, was it reasonably related in scope to the circumstances that justified the interference in the first place? So the court evaluated the facts that I just read them to you of the search, taking that into account, that test that they said. And they said, first, the court concluded that the search was justified at its inception. The initial report from the teacher that TLO had been smoking in violation of school rules constituted reasonable suspicion that cigarettes were in her purse, a fact that would be relevant to the smoking accusation. Second, the court noted that the discovery of rolling paper provided reasonable suspicion that TLO possessed marijuana, and this justified the further search of her purse. Since the school administrator's actions were justified at the inception and were reasonably related in scope to the circumstances that justified the interference, the search was reasonable. So, although the court held that the Fourth Amendment applied to the school administrator's actions, the court ultimately determined that his actions, the administrator's actions in this case, didn't violate the Fourth Amendment. So, students can be searched by administrators, not law enforcement, administrators, when there's reasonable grounds to believe that the student has violated the law or a school rule. So for officials, they only need reasonable under the circumstances to meet the test. Let's talk about drug testing. Is there an invasion of a student's privacy when a school requires drug testing? And if you've played sports in school, you know that, and you may just assume that that's just something that goes along with the process. But this actually was a fought case that went all the way to the Supreme Court in 1995. The Acton case, it's mentioned in the book. And in that case, the Oregon school boards had a random drug testing policy for student athletes. And the question was whether or not drug testing was reasonable. There's that reasonable word under the circumstances. So, a little bit about the case. In response to concerns about increased drug use among students, the school board in Oregon, Oregon instituted a drug testing policy for student athletes in 1989. The policy focused on student athletes because the board viewed them as leaders of drug abuse activities in the high school, and because there were concerns that drug use would increase the risk of sports-related injuries. The policy required all those who wished to play on athletic teams to submit to drug testing by urinalysis. In 1991, James Acton, who was a 7th grader, was suspended from participating in athletics for a season after he and his parents refused to sign a consent form for drug testing. The Actons filed a lawsuit, and this case climbed all the way up to the Supreme Court, working its way through the court channels. The case was argued in 95 before the court. The court noted that the Fourth Amendment, which forbids the federal government from conducting unreasonable searches and seizures, was extended by 14th Amendment to cover searches and seizures by state officers, including those at public schools. Since the collection and testing of urine under the school policy was a search and thus subject to the Fourth Amendment, it was necessary to turn to the question of reasonableness, remember under our TLO's case. So to that end, the court pointed out that even though school officials are agents of the state, they have the authority to act in safeguarding the children in their care, like a parent. The court then cited the fact that school children are already subject to physical examinations, such as scoliosis testing, and to various vaccinations. According to the judges, the justices, student athletes have a lesser expectation of privacy than their peers who are not athletes. The court noted that locker rooms offer little privacy and that student athletes voluntarily subject themselves to a greater degree of regulation as well. In addition, the school policy featured various privacy safeguards, such as requiring monitors to stand at a distance while athletes provide the urine samples. Lastly, the court took the view that the board had articulated an important interest in light of its wish to deter drug use by student athletes and to keep them from harm. On the basis of those findings, the court found that that policy met all the constitutional parameters, and therefore drug testing for athletes is within the bounds of the Constitution. The case was later extended in 2002 to students who participate in competitive extracurricular activities, didn't violate the Fourth Amendment. So it wasn't just limited to sports come 2002. So students participating in competitive or extracurricular activities can be subject to drug testing. And then our next question turned on, can schools, administrators, search a student who has been accused of or who they have suspicion of possessing drugs? It's one thing to do drug testing, require students to do drug testing when they're participating in, let's call it school activities or sports. But can they just randomly search students? And that case was a very big case in 2009. Stafford Unified School District versus Reading. The book outlines just about the entire case. Vice Principal, and there's a few important facts that I think need to be fleshed out that are in the book. Vice Principal Carrie Wilson discovered that students in the school were passing out prescription strength ibuprofen and over-the-counter naproxen. These pills were common pain relievers that were equivalent to one Aleve pill. Wilson found some pills on one student who stated that she received the pills from Savannah Redding, who is our person in the case. Wilson confronted the principal, vice principal, confronted Redding, and Redding denied having knowledge of the pills. Wilson searched Redding's backpack, which, by the way, Redding consented to. She said, "Here, look at my backpack," and did not find any more pills. Wilson then had a female school official take Redding into the school nurse's office and perform a strip search. Redding was directed to undress down to her underwear and then pull out her bra and panties and shake them. This exposed her breasts and pelvic area. Redding described this as embarrassing, frightening, and humiliating, and no pills were discovered. And Redding sued the school district and 7 of the officials for violating her Fourth Amendment right of illegal search and seizure. So the issue here is whether 13-year-old student's Fourth Amendment unreasonable search and seizure right was violated when she was subject to a search of her bra and underpants by school officials acting on reasonable suspicion. What was the reasonable suspicion? It was one student's word against another, because even on consent, she let her look at the bag and there was nothing in the bag. So reasonable suspicion that she had brought forbidden prescription and over-the-counter drugs, ibuprofen, to school. Because there were no reasons to suspect the drugs presented a danger or were concealed in her underwear, the Supreme Court held that this was a violation of her constitutional right. No strip searches. But it leaves open a big question of whether if this was a more serious drug, then that could pose a danger. What if it's like cocaine, heroin? Would that give them a right to do the search? I would think not, based on similar evidence, one word against another. And I will tell you that inmates in a prison can't be strip searched without some level of cause, and in a lot of cases without a warrant. So to impose such a standard on children seems a little unrealistic to me. So good outcome. No strip searches in schools. They'll probably need the law enforcement with a warrant to do something like that. But we'll see. This was the last case in 2002. Interrogations, students being questioned. Do they have a right to their, what we call the Miranda Warnings? Can students be questioned by police on school grounds with administrators present? And I'll tell you, this happens a lot. And most of the time, the police will just sit in the room and let the administrator do the questioning. And you will see why when we talk about the JDB versus North Carolina case, which is in the book, and it's not fleshed out enough. Those of you who want to work with students, I think these cases are very important. That's why I'm fleshing them out more. In 1966, in the landmark case of Miranda versus Arizona, the Supreme Court held that a person questioned by law enforcement officers after being taken into custody or otherwise deprived of his freedom of action in any significant way must first be warned that he has a right to remain silent, that any statement he does make may be used as evidence against him, and that he has a right to the presence of an attorney, either retained or appointed. Statements made by the defendant when law enforcement has not complied with this rule may not be admitted as evidence of guilt in a criminal trial. So, an officer's obligation to administer Miranda warnings attaches only when there has been such a restriction on a person's freedom as to render him, quote unquote, in custody. In determining whether an individual was in custody, a court must examine all the circumstances surrounding the interrogation in determining whether there was a formal arrest or a restraint of freedom of movement of the degree associated with a formal arrest. So that's a little background regarding Miranda. When you take criminal procedure, you'll learn lots more about it. So JBD was a 13-year-old student in the 7th grade when a uniformed police officer on detail at the school escorted him from his social studies class to a conference room where 2 school administrators and another police officer were waiting. In the closed-door room, police investigator DiCostanzo questioned JDB for 30 to 45 minutes about some recent neighborhood break-ins. Among the items reported stolen was a digital camera that had been found at the school and seen in JDB's possession. JDB first denied his involvement. However, after the investigator pressed him for additional details about his presence in the neighborhood after one of the break-ins and confronted him with the stolen camera, and after the assistant principal urged him to tell the truth, JDB asked whether he would still be in trouble if he returned the stuff. And the investigator then warned JDB that he may face juvenile detention. JDB confessed. And then at that time, the investigator told JDB that he could refuse to answer questions and was free to leave. Asked whether he understood, JDB nodded and provided further details, including the location of the stolen items. He also wrote a statement at the investigator's request. When the school day ended, JDB was permitted to leave. So, the state of North Carolina charged JDB with breaking and entering and larceny. His attorney, who was a public defender, represented him and moved and asked that his statement not be allowed as evidence, claiming that he did not receive those warnings that I told you about, the Miranda warnings. The court said, nope, those are fine. They can come in. And so now this case goes all the way up to the Supreme Court, and the question is whether the Miranda custody analysis includes consideration of a juvenile suspect's age, more specifically whether a child's age would have affected how a reasonable person in the suspect's position, the 13-year-old, would perceive his or her freedom to leave. And the answer is yes, so long as the child's age was known to the officer at the time of police questioning or would have been objectively apparent to any reasonable officer. Its inclusion in the custody analysis is consistent with the objective nature of the test. Just as police officers are competent to account for other objective circumstances that are a matter of degree, such as the length of questioning or the number of officers present, so too are they competent to evaluate the effect of relative age. This was a split court decision, 5-4. But the 13-year-old, so the police have to account for the age of the person they are questioning. How must they consider it? They have to determine whether they understand, but they certainly have to give those warnings up front. So his confession was tossed out under these circumstances. It was unconstitutional because it didn't appear apparent that the police took into account the age of the person. Of course, I would have a big problem with the fact that the rights weren't read up front, but after he confessed, oh, and by the way, you don't have to answer our questions. That should have kind of came first, but the court didn't go there. So states now have statutes and parameters about questioning children, and police have learned to get around it, as I indicated up front, allowing the administrators to take the reins for questioning, especially when something happens on school grounds. If it's the administrator doing the questioning, law enforcement sitting in the room, there's a lot more wiggle room regarding it, even though the official acts as a state agent. We're back to that whole what's reasonable discussion. But in New York, if a police officer is going to question a student, a parent has to be notified if the child is 18 or under. So, interesting cases. As you may know, the Family Educational Rights and Privacy Act, or FERPA, gives students privacy rights in their school records. In 1994, Congress, through the America's School Act, allowed schools to disclose records under certain circumstances. Those are outlined here in the slide. They were in the book. State law authorizes the disclosure. The disclosure is to a juvenile justice agency, like a court system or probation, or social services, even, who prosecutes those cases. In New York State, those are the ones who prosecute the cases. The disclosure relates to the justice system's ability to provide pre-adjudication services to students. State or local officials certify in writing that the institution or individual receiving the information has agreed not to disclose it to a third party other than in another juvenile justice agency. Where school administrators and students tend to bunk heads is free speech. Free speech in schools, another area. We have two categories: passive speech, active speech. We have speech on school grounds, speech off of school grounds but relates to school activities or individuals, and speech with a religious message on school grounds. That's what we'll cover. Passive speech. The first case involving speech in schools was Tinker versus Des Moines Independent Community School District. This is a big case. This is the first time the Supreme Court looks at the issue of free speech on school grounds. 1969, at a public school in Des Moines, Iowa, students planned to wear black armbands at school as a silent protest against the Vietnam War. When the principal became aware of the plan, he warned the students that they would be suspended if they wore the armbands to school because the protest might cause a disruption in the learning environment. Despite the warning, some students wore the armbands and were suspended. During their suspension, the students' parents sued the school for violating the right to free speech. Ultimately, the Supreme Court said that students do not shed their free speech rights at the schoolhouse steps. The school cannot prohibit the expression of opinion based on a desire to avoid unpleasantness. They must show that the speech will interfere with the discipline required to operate the school. In the case, the court said, basically the speech has to substantially disrupt. This is not just some unfavorable points of view that the school wants to suppress. So substantial disruption is what's needed if we're talking about passive speech. Passive speech, wearing an armband, wearing a t-shirt, a button that has a political point of view on it. In 1986, brought us another case. There's a 1986 and 1988. Two cases involving speech again. The Bethel case and the Hazelwood case, as I like to refer to them in short. Let's talk about Bethel. There was a student, Matthew Frazier, who was a student at Bethel High School, which is in Washington State. He gave a nominating speech for a classmate who was running for student president. The speech, which occurred at the school assembly that was attended by approximately 600 students, it featured numerous sexual innuendos and references, causing the audience to react in a variety of ways. Some appeared embarrassed, while others yelled and made obscene gestures. Prior to the student assembly, two educators had warned Frazier that he should not give the speech, and that if he did, serious consequences could result. The following day, the assistant principal told Frazier that he had violated the school's policy prohibiting the use of obscene language. As punishment, school officials suspended him for 3 days, removed his name from the list of possible graduation commencement speakers. Although Tinker established that students should be afforded free expression rights while at school, the Supreme Court held that their rights are not equivalent to an adult's freedom of speech. Moreover, the court pointed out that the sexual content of Frazier's speech was distinguishable from the non-disruptive political speech that was at issue in Tinker. The court added that the state has an interest in protecting children from vulgar and offensive language, and that school boards should thus have the authority to determine what speech is inappropriate. Although school officials should allow controversial views to be expressed, they must balance that interest with those of other students who may be offended by certain language. The Supreme Court thereby found that the school's actions were not in violation of the First Amendment. And then in Hazelwood, students in a Journalism 2 class at a high school in St. Louis, Missouri, they wrote stories about their peers' experiences with teen pregnancy and the impact of divorce. When they published the articles in the school-sponsored and funded newspaper called The Spectrum, the principal deleted the pages that contained the stories prior to the publication without telling the students. And the students claimed that this violated their First Amendment rights. The case went all the way up to the Supreme Court, and the court held that the principal's actions did not violate students' free speech. The court noted that the paper was sponsored by the school and as such, the school had a legitimate interest in preventing the publication of articles that it deemed inappropriate, and that might appear that the school had accepted or approved those points of view. So these involve a type of active speech. The next question is, can schools regulate off-campus speech? Bong hits for Jesus, a big case in 2002. The last time that the Supreme Court addresses the issue of free speech, by the way. Joseph Frederick, who was a senior at Juneau Douglas High School in Alaska, he held up a banner that said, it was a huge banner, you can Google it and see the photo, but it took a bunch of students to hold it out. It was quite large. It said, "Bong hits for Jesus," during the Olympic torch relay through Juneau, Alaska on January 24th, 2022. His attendance at the event was part of a school-supervised activity. And the school principal told Frederick to put the banner away because it could be interpreted as advocating illegal drug activity. When Frederick refused, she took the banner, and then he was suspended for 10 days for violating the school policy on forbidding advocacy for the use of illegal drugs. The U.S. Supreme Court ruled that the First Amendment does not prevent school administrators from restricting student expression that reasonably is viewed as promoting the use of illegal drugs when at a school-regulated activity. So, if you're off campus, but it's a school-regulated activity, the schools can restrict speech reasonably, depending on the point of view. And if it, in this case, is promoting the use of illegal drugs. So this was the last case that the Supreme Court addressed relative to student speech. Student speech on the internet has created a number of cases. However, the Supreme Court has not issued a ruling, so the decisions of the lower federal courts are all over the place. The book gives you an example of how that is. In one case, courts ruled one way, and in another case, they ruled a different way. Whether the speech is on a website, Twitter post, YouTube video, Facebook page, the question is, can the school regulate it or punish students because of it? So I'm going to kind of give you the lay of the land here to sum it up. Here is the current state of the law on this issue involving regulation of students off campus, off grounds, internet speech, meaning they created it on their own time, not while they were in school, and nor did they create it when they were on the grounds of the school. So number one, if the speech makes its way to the school, meaning it is accessed using school computers or technology, and it causes a substantial disruption, per that Tinker case, it can be regulated. The school can regulate it. When the speech is not accessed at school using school technology, the courts are split. One point of view, which is the minority, they can't regulate it. They can't violate speech. They can't regulate it. Can't happen. Oh, sorry. I'm going to say, take that back. Taking that back. They can regulate. They can regulate. I'm sorry, I'm going to cough here in a moment. Okay, sorry about that. Two rules. If the speech makes its way to the school meeting, if the speech makes its way to the school, meaning that it's accessed using school computers, the school can regulate. That's clear. The second component, when the speech is not accessed at school using school technology, the courts are split. One point of view, can't regulate it. Can't happen. If they do, they violate free speech. The other point of view, and the more popular view, is that if the speech is about principal, teacher, administrator, student, i.e. somebody connected to the school, and the speech causes a substantial disruption, it can be regulated. So students are accessing it, on their phone at school, or they're talking about it because they saw it the night before, and it's causing a disruption in school, that speech can be regulated, which means the student can be punished. All right. School prayer. These are our two First Amendments coming head to head: free speech and free religion. There's a couple cases. The first one was whether a Texas school board policy that allowed student-initiated prayer before varsity high school football games, if that was a violation of the First Amendment, which is generally prohibited governments from establishing, advancing, or giving favor to a religion. And the court said that, yeah, that would violate the First Amendment here. The court it would over the school's public address system by a speaker representing the student body under the supervision of school faculty and pursuant to a school policy that explicitly and implicitly encourages public prayer is not properly characterized as private speech. It is a public speech, and that such message undermines the protection of minority viewpoints, and hence that is a violation of they call it the Establishment Clause. It suggests that the government is promoting religion in this case, and you can't do that on a public school campus. So that it kind of regulates free speech relative to a student who wants to give a school address and a prayer, but it's all pursuant to, one, they're an elected person of the student body, and the event is supervised by school faculty, and there is a school policy that encourages public prayer. So taking all that in hand. But on the other side of that, in New York, there's a New York case, Good News Club, 2001, in which the Supreme Court ruled that under the First Amendment's freedom of speech clause, a religious group in New York State could not be denied the use of a local public school's facilities after school hours, since the facilities were available to other groups promoting similar issues, those issues being, moral and character development of children. So if the school opens its doors for after school to allow clubs and activities to happen, you can't pick and choose who that group is if they're doing what they're supposed to be doing. So in this case, it was a religious group, and that was allowed to happen, and the school violated the freedom of speech relative to that group. All right, last point, a little long in the All right, last point, a little long in this discussion, but these are all very important because they come up. Can schools use corporal punishment to discipline a student? You might be saying, oh, heck no, but yes. And this was a common practice in early American history up until the late 1970s. So this is how, that's not that long ago. You guys might think, well, that's forever ago. It's not really that long ago. In 1977, the U.S. Supreme Court ruled that school corporal punishment is constitutional, which leaves states to decide whether to allow it. And there are 19, not 20. The book says 20. There's 19 U.S. states currently that allow public school personnel to use corporal punishment to discipline children from the time they start preschool until they graduate 12th grade. These states are Alabama, Arkansas, Arizona, Colorado, Florida, Georgia, Idaho, Indiana, Kansas, Kentucky, Louisiana, Missouri, Mississippi, North Carolina, Oklahoma, South Carolina, Tennessee, Texas, and Wyoming. I wanted to name them all off to then ask you the question, does that surprise you? Do any of these states have anything in common? Corporal punishment is defined as the use of physical force with the intention of causing a child to experience pain so as to correct their misbehavior. It is synopsis with physical punishment, but the term corporal punishment is used because that's what school districts put in their policy. That's the terminology they use, and that's what they use to define it. Although corporal punishment by parents tends to take the form of spanking a child's buttocks with an open hand, in schools, a teacher or administrator, typically the administrators, when they administrate corporal punishment, they use a large wooden board or a paddle to strike a child's buttocks. According to the Civil Liberties Union, almost 250,000 of students are subject to corporal punishment, and a disproportionate number of them are students with disabilities, and the punishment is usually the result from conduct related to that disability. So I think a big problem is to have corporal punishment. Hopefully the rest of these states will follow. Schools justify this type of punishment under the concept of in loco parentis, which means in place of the parent, because that's where kids go. Kids are placed in school, and the school acts as a parent. The last point, very important. All of these were very important, but the last point regarding students' rights in schools is the connection with suspension and expulsion, because you don't get these cases, these Supreme Court cases, unless a child is suspended or expelled. If they just get a slap in the wrist or they have to sit in detention, we never know about it. The Supreme Court has ruled in 1976, Goss versus Lopez, that if a student is to be suspended for more than 10 days, they're entitled to a hearing. Usually it will be conducted before the board, a school board, but any decision is subject to court review, and it's recorded. That's how a lot of these cases get to Supreme Court. They started a school hearing, it's been recorded, the school board makes a ruling in favor of the school, and then the child takes it into the court system or their family. Why is having a hearing important? Keeps the school in check, protects the students from unreasonable, excessive, and arbitrary discipline, and allows them an opportunity to have their case heard in school. And that concludes this discussion on legal rights in school. Sorry, it was a little longer than anticipated.